Welcome to the Business SOS podcast. This is Rich Sierra with the Florida Small Business Legal Center. This is episode number 67 of Business SOS. We're excited that we continue providing you some information and legal information, how to navigate the legal challenges that you face as a small business owner. Today, I'm going to do something a little different, and I'm going to talk about the top 10 legal questions to ask every business owner should ask a business lawyer. So they're common questions that I get, so I'm going to go through them. I'm going to do the 10 and maybe give you a bonus one if we have time. And I talked to a number of business owners, and through my career now, I'm going in my 20th year in business, and I've spoken to thousands of business owners throughout my career, and we get common questions. Whether you're a startup, whether you're kind of in the mid of your career, on your business career, you're finishing up. So there are a variety of questions that we get. I'm going to tell you about the most common ones that we receive. One of them is, what type of business structure should I have? And there are a number of them, especially if you work by yourself. Some people have a sole proprietorship that you're basically working your own, and that is your business name. And the checks go to your personal account, and that's the most simplest form of business ownership. It is not recommended simply because you have unlimited liability when you're working by yourself and you don't have a corporate entity. So a common business structure that I recommend, that includes setting up a corporation, and we do that through somebiz.org, and we prepare articles of our incorporation. And by having the corporation, you're basically insulated from personal liability for corporate acts. There are some exceptions to that. I'll talk about them in a few minutes. There's also the LLC, a limited liability company. Limited liability company is what it means. Is basically the company is similar to a partnership, except it has the protections of a corporation. And there's some nuances to that, but for a corporation, whether you have a corporation or an LLC, you have similar protections with respect to personal liability for corporate acts. And I'll give you an example. Say you have a vendor that comes to your business and they do carpet cleaning. Just to give you a simple example, they clean your carpets and then they send you an invoice for, say, $1,000. And for whatever reason, you were not able to pay that bill. Something happened, your business went down, and that bill was not paid. The carpet cleaning company sues your business for the $1,000 bill. They're able to get a judgment. They can only go after the business. They cannot go after you individually because that was a corporate act. And I'm using a very, very simple example here, but just to understand why it is important to have a corporate entity when you're doing business is to protect yourself from personal liability, among other things. And from that, you also can designate what is called a sub-S corporation. Whether you're a corporation or you're an LLC, you can designate it as a sub-S with the IRS. What that means. So all your profit and losses are flow through. For the corporation, you only basically pay for the profits that you make in your personal taxes. Let me explain that a little bit better. So say, for example, your business received a $50,000 profit in the last year. So that profit, the corporation does not pay the taxes. So that it flows through your personal tax returns, and you end up paying the taxes on your personal tax returns from the corporation's profits. Likewise, if you have losses, say you have $50,000 loss, that flows through your personal income tax return. So it's a very simple example, but what you hear is avoid double taxation. You don't pay as a corporation, then you don't pay personally as well for the corporation profits. So many small business owners elect the S corporation that way. And my recommendation, if you're interested in these types of designations, talk to your CPA, talk to your accountant, simply because they do this every single day, and they'll be able to advise you about the tax benefits of selecting a sub-S. But many business owners choose the sub-S corporation for that reason alone. There's also partnerships, although exactly what it means is a partnership where there's 2 or 3 individuals and they register as a partnership. In this particular case, the partners individually have the liability. I have not seen too many partnerships per se. What I've seen more is that the partnerships are integrated into an LLC. And so that way you get the benefit of the partnership while you also get the protections of the LLC as well. Question number 2, how do I protect my personal assets from business liabilities? And I went over that in the point of the prior point, is forming a legal entity, whether it's a corporation, LLC. There's one way that you can actually protect your personal assets, personal liabilities. Keeping business and personal expenses separately, that's also a good idea. So that way you have your business account and personal account separately as well. Another point that another item you can actually use, or another strategy, is avoid personal guarantees. And to the extent that you can, I think I'll use that caveat, simply because when you have in many business contracts, especially lease agreements, it is very common for small business owners to have a personal guarantee to the performance of that lease. So you sometimes can avoid signing a personal guarantee. Sometimes you can't. Another example of that you will not be able to avoid a personal guarantee would be when you have bank loans or any type of business loan. It is very common that when you have a business loan, they also make you sign a personal guarantee. So that's why the point is the strategy is avoid it to the extent that you can, simply to keep the exposure that you have on that particular debt strictly to the corporation. So sometimes you can avoid them, sometimes you can't. Another way that you can protect your personal assets from business liabilities is to maintaining proper insurance coverage. That includes general liability coverage and also professional liability coverage. So those two. General liability is what it means. Anything, somebody goes to your premises, it falls, something happens, you get sued, you call your carrier basically takes over that particular litigation. And professional liability is exactly what it means. If you're a professional, something happens, a mistake takes place, there's a claim against you for whatever reason, and then you call your carrier and say this happens, and then the carrier takes over that particular case. So there's no foolproof to do this. In other words, you have to develop different strategies to mitigate the risk. It's about reduction of the risk and the probabilities of the event that could lend itself to you having some type of personal liability to reduce that probability from happening. Number 3, I have a partner in my business. Should I have a partnership agreement? What should be included? And I have had a couple of episodes talking about partnership agreements and shareholder agreements. And the short answer to that question is yes. I recommend that if you have a partner, have a partnership agreement. If you have an LLC, have an operating agreement. If you have a corporation, a shareholders agreement. They all do pretty much the same thing. But we call it different names, but it's basically that you need to have an agreement between the shareholders, the partners, or the members, if it's an LLC. And it is something that I highly recommend. And it surprised me how many businesses, how many LLCs, as I talked to, do not have that. They do not have a partnership agreement. And then they call me and they say, hey, this happened between my partner and I said, do you have a partnership agreement? The answer is no. So I said, okay, so let's start from that point. So you got to have a partnership agreement, and I'll tell you what some of the components that should be included there. And of course, I'm trying to do this kind of a rapid questions and answers. And I recommend that if you want more in-depth analysis or a discussion of this topic, go to some of the episodes that I talked about partnership agreements, and I go into more specifics about what should be included. So I'll give you an example. Some of the items that should be included, obviously, who are the partners and what is the percentage of ownership? Again, who are the partners and what is the percentage of ownership. It's very important. I've seen agreements that do not answer that question, so I have to include it there. And sometimes they say, well, this is the partners that we have in this agreement, but we have another partner that is a silent partner that's not included there. No, every partner should be included in the partnership agreement. That otherwise, whoever's not included there may not have any rights within the company. What are the voting rights of each individual member or partner? Very important. And every partnership is different. Sometimes you have someone who you can have 50-50 partnerships, but they have by agreement, they have made a provision that said this particular partner has greater authority to make these types of decisions, whether it's expenditures up to a certain amount, over $1,000, whether it's dealing with vendors, dealing with customers. This particular partner can hire and fire employees without consulting the other partner. So understanding that level of authority is very important. In the voting rights, for certain items of certain decisions, has to be 50-50. For certain decisions, has to be unanimous. It's important to have that in the agreement. And I'll give you an example. Say one partner thinks that it's time to sell the company. It is time to go ahead and divest and sell it. And you want to make sure that that is unanimous. That's my recommendation, a unanimous decision on whether or not to sell the business. Obviously, something as minor as going to Office Depot or just buying some office supplies, you don't really need to consult the other partner. It's something that is routine in the normal course of business. Getting into a very expensive lease, changing locations, something that affects the business structure itself, that's something that has to be discussed about who has the authority and what, to make that decision on how many votes or who out of the partners you need, how many partners you need to really go forward with that decision. Decision-making process, I think I went already. Again, it's important to have delineate the roles and responsibilities of each partner. Sometimes you have one partner that deals primarily with management and operations of the business, that deals with the day-to-day running of that business, and you have another partner that might be the financial manager. How much money spent, where and how. The partner might be involved with collections. So that is very important, and I'm surprised in how many operating agreements and how many shareholder agreements I see that do not include that. And what happens here is that they download, many people download templates from the web, and some of them are a good starting point, but do not answer those questions. And then when I see them, I'm like, it doesn't really give me the information about how you guys run this business, how you're running the business, who has authority to do what. So it is important to have that within the agreement. Profit sharing. Profit sharing, when will you as an owner and your partner will take distributions out of the business and how the profits will be shared and when. It's going to be monthly, it's going to be quarterly, and within the profit sharing or annually. Within the profit sharing, you also want to include, it's going to be a salary paid to the owners and how much and when, if there's going to be an increase. So those are decisions that should be included in this document. Also, if there's a minimum cash flow of capital requirements, if you want to have a certain amount available for working capital, and then that's, it's a certain minimum, it should be there, whether it's an amount, whether it's a certain benchmark to maintain operations. So we will keep in an operating account a month's worth of expenses. And then once we have that, and I'm giving that as an example, then we can take distributions, or 2 months or 3 months, whatever you feel comfortable with your business, but that should be included there to avoid depleting the bank account and having no working capital to work with. Another important section that I see that is avoided or is just downloaded and templated, and then it becomes a problem later on when there's a dispute, is the dispute resolution clause on the contract. And that's extremely important. And that's one of the first things that I look for when I get when there's a partnership dispute. I said, do you have an operating agreement? Do you have a partnership agreement? They say, yeah, I have one. Great, send it to me. And I look for the dispute resolution section. It's either non-existent or it's very vague. And I said, okay. So that's what we have to, when it's non-existent or vague, then the answer is you're going straight to court. There's no other mechanism in place for dispute resolution. Sometimes, in the agreements that I draft, I include a mechanism in place to resolve disputes. An example could be something like, before we actually file something in court, we go to mediation first. We'll send a notice of mediation to see if we can get it resolved before we actually go into court. And the reason for that is that, sometimes, especially with partnership disputes, they stem from misunderstandings or lack of communication. So by spending 4 hours with a mediator, it might resolve the issue, at least will narrow down the issues, and forces the partners to communicate for 4 hours, even paying someone that perhaps they never had that meeting in the first place. It is a way to create that stopgap measure before you actually file something in court, which will escalate the expenses significantly. So a dispute resolution is very important to have. And again, this is just a very small outline of what I believe should be included, but there's actually more, there's more details to be included here as well. And I believe I talked about my operating agreement questionnaire that I send out that I use as part of my drafting process. And I think I already discussed why it is important to have one. It's better to have one. It keeps things clear. And if you're developing a draft of an operating agreement or a partnership agreement, and you do not agree what should be included there, you got to question whether this partnership is going to work. You will have disagreements along the way with your partner. It's human nature. The question is whether disagreements can be resolved through conversations, or it's going to escalate to a point that it may end up having a third party come in and intervene and assist you resolving that matter. Number 4, what should I include in client's contract? Many of my clients, some of them have contracts, some of them don't. For clients, my recommendation, to the extent that you can, unless it's you're selling retail or a restaurant or you're providing services, let me rephrase. If you have a business that provides services to other businesses or consumers, my recommendation is to have a contract. If you're a business that is a retail business, that people come in and just small transactions, or say, for example, a restaurant, you don't need a contract for consumers. It's just not practical to do that, and it's not the standard practice. So for those of you who provide services to businesses or to other individuals, a contract is something that I would advise. And why should you have a contract? It keeps things clear, and it avoids problems in the future. And what should you include in this contract? Obviously, the parties to the contract is very important. You need to know who you're contracting with, and making sure that the person that you're contracting with has the authority to bind this contract, enter into the contract. What are the terms? What are your obligations in the contract? What are you going to provide in the contract? And also, what are the payment obligations? What are the payment terms, and how and when? Deadlines. When is the project going to be completed? And when is expected? And what happens if it's not completed on time? The service you're going to provide. Again, dispute resolution, just as I mentioned before, that's something that should be included in every contract. It makes things very clear in how to resolve them. Also, within the payment terms, what happens if the customer does not pay on time or does not pay? Will you be entitled to attorney's fees? And I want to make this point, that if you have a contract and someone owes you money, a customer owes you money, and you sue to collect on that debt that is owed to you, if you do not have a provision in your contract that states that you're entitled to recover attorney's fees and costs in pursuing the claim for collections, you're not going to be entitled to collect attorney's fees. In Florida, you can collect attorney's fees in two different methods. Either you have a statutory claim that you're suing on, or you have a provision in your contract that allows you to collect attorney's fees. So it's very important to have that, and I see many, contracts coming my way that is not included, and then what happens, you're losing two ways. Not only you're losing the fact that you don't have the money that is owed to you, but then you got to spend money to try to collect in the money that is owed to you. So there's a diminishing return there. So I just want to make you aware of that. Number 5, how do I protect my intellectual property? That's a very broad question, but I want to do some highlights here. And if you recall a few episodes back, I brought L.A. Perkins. She's an intellectual property attorney. And again, it's about like 2 or 3 episodes back. And I had 2 segments with her that we talked about protecting your intellectual property. In fact, he's author of a book, Why Brand Protections Matter, and it's available on Amazon as well. So I thought I'd give LA a shout out here today. And so one of the suggestions that I provide, if you have a logo or a brand that you're utilizing for your business, get a registered trademark. When you do that, you have nationwide protection on your trademark. Takes about 10 to 12 months to get the actual registration. And I recommend you use an attorney to do that, simply because it'll help you. It'll do the process more efficiently, and you'll have less mistakes along the way. So somebody who does this every day for a living, a professional like L.A. Perkins, you can will go much smoother than if you do it yourself. Copyrights, if you have any type of intellectual property that can be copywritten, that whether it's a text, whether it's a manual, whether it's any type of presentation, even logos can be copywritten if it's on the design. So register the copyright with the Copyright Office as well. Any type of protection you can have from the federal government, go ahead and use it. And also, to get me with patents. If you have an invention, you have an idea that you would like to protect, that's part of your intellectual property, then registering that idea or invention with the United States Patent and Trademark Office is something that you will want to consider. And for that, I highly recommend you get the advice of a registered patent attorney as well. And last but not least, you have trade secrets. Trade secrets you do not publish for obvious reasons because you're trade secrets. And I'll give you an example of a trade secret is your customer list, any type of formula, any recipes that you have that you do not want to go on in the public, that is protected. That's something that you created because you generate economic value from that trade secret. One of the most famous trade secrets is the formula for Coca-Cola. It's not published anywhere, and it's in a vault, I believe, in Atlanta, in the Coke Museum. So that's an example of that. But the way also, if somebody needs to have access to that particular intellectual property, the way you can protect that is through non-disclosure agreements. And an attorney can help you draft that. I recommend you do not do that on your own in reference to drafting an NDA, because there are intricacies, there are details that you may not have an attorney will be able to help you with that. And when you look at the value of the trade secret to you and what you're going to generate from that trade secret, it's worth paying an attorney some money to get it done right. It's your investment, it's your protection, so I recommend you do that through an attorney. Question number 6, I've been sued, what should I do? And I've done an episode on this, and I spent quite a bit of time talking about, what happens if you get sued. And I'll just give you some quick tips. The first tip that I give you is do not panic. And I understand that being sued it is stressful. Somebody's suing you, and 9 out of 10 times they're inflammatory statements that are not true. Okay? And it's very upsetting and very unsettling. that you'll have somebody that at some point you had a business relationship with, or somebody that believes that you were negligent or you fault them in some way, filing a lawsuit in state or federal court, which is in the public domain, making allegations against you. So it is very stressful, and you have some stranger coming to your house giving you papers. It's just not fun. So my recommendation first is don't panic, because you have 20 days instead of Florida. If it's state court, if federal court, you have, I believe, 21 days. So you have time to respond, okay? But what you have to do next after that is hire an attorney as soon as possible. Do not wait the 19th day to start calling lawyers. It's basically the next day after you receive that, you get in the phone, you got to prioritize your day to handle that first. Don't put it aside, because every single day on that grace period counts. So the first thing you do is start contacting lawyers, making appointments with attorneys, whether it's phone or person or in Zoom, and begin the process of retaining counsel. That's very important. Another point that I like to make is that do not answer a lawsuit by yourself. It's not something that I recommend, and for a number of reasons. When you answer a lawsuit by yourself, you might be waiving defenses. That then when you hire an attorney, the attorney might have a difficult time overcoming the statements that you made. Okay, so do not answer it by yourself. Number two, when you do that, answering a lawsuit by yourself, you might be making admissions that may not necessarily have to be made if you have contacted an attorney first. And what has happened in the past, in some cases, is when somebody calls me, I got this lawsuit and, I need an attorney. And it happens with businesses. Businesses in Florida, anything above small claims, you need an attorney to represent the corporation. The corporation cannot be represented by the individual. That almost has to be a licensed attorney. So what happens, the business owner sometimes writes a letter to the judge denying everything, and then write a whole explanation about what happened. They send it out, and then the other attorney files a motion to strike, because you cannot file something on your behalf as a corporate entity. It must be through an attorney. And then that's when I received the phone call. The judge said, okay, they struck whatever I wrote, but it gave me 10 days to get a lawyer, or a little bit more, 15 days to get an attorney. If I don't get an attorney, it's going to be, they're going to get defaulted. So, and I said, what have you done? So, well, I wrote a letter to the judge. So we go back and look it up, and I see all kinds of list of items that should have not been included there. It's already stricken. It's as if it never happened, but the other attorney already knows that. So understanding how to provide information is essential. So obviously we do what we can to fix it, but it's an error that could have been avoided. And once you hire an attorney, follow the instructions. So follow his or her instructions is very important. Don't go rogue. Don't go start filing things. Listen to the attorney. Let the attorney handle it. He's the professional that will handle this. I think for this episode, what I'm going to do is following, because we have some material. I'm going to leave the other ones for the next episode. So I will leave you with this one, and then I'm going to go ahead and complete the second ones in the next episode. So for today, we'll leave you with the first 6, and then I'll finish with the 7 to 11. I have a bonus one for you on next week. If you have any questions about some of the items that I talked about, and I'll give you a recap of what we discussed today. Okay. You talked about business structures today. I talked about how to protect your personal assets from business liabilities. We talked about the importance of having partnerships agreements. We talked about what should you include in client contracts. We talked about how to protect your intellectual property, what to do, and also what to do if you have been sued as well. So for today, we'll leave it at that. I certainly appreciate you listening to me today. If you have any questions about any of the topics that I talked about today, you can send me an email at richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. And if you want to give me a call, my number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, is available on Amazon, Barnes & Noble. You can ask for your local bookstores. If you like the podcast, please give us a review, share it with your friends. We're available on Apple Podcasts, Spotify, wherever you enjoy your podcast, your shows. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.